This is a lecture on products liability, in particular the strict liability aspects of it. Now, on this lecture, I'm going to do two things. I'm going to tell you about strict liability for products liability, and secondly, I'm going to go through the analysis of several fact patterns so that we get used to seeing how to do the analysis using all of the mechanisms for products liability, all of the theories for recovery for products liability. Now, in order to follow the lecture, where we're using the examples to illustrate how to do the problem, you need to know the problem. And it's the same problems we've been using on the other lectures, but if you haven't read them, it's important, imperative that you stop the video, put it on pause, and go read the problems. They're on the network, and you can download them and read them. The three problems that you need to read are the problems from the February 1997 torts question, same ones we had before, the July 2002 torts question, and the February 2006 torts question. In those questions, the problems are, you recall that Peter, in that question, Peter injured his foot, Sally lost her vision, the child was injured by the airbag, and then the problem that is my problem, where the Gale's house was burned down and Peter's guitar was destroyed. So would you please stop the video now, put it on pause, read those questions, and then let's start again. So we're on pause now. Okay, assuming that you have read the question, let's begin our analysis. And I begin by first reviewing the facts. And let's start with the problem with Peter and his injured foot. Now you recall that what happened with Peter is that Peter went to a store called Homeco and bought in a box a concrete cutter. Now I've called that concrete cutter a lawnmower on one of the other videos, but it's the same piece of equipment. And so he bought this concrete cutter in a box, took it home in the box, opened the box, assembled it correctly according to the facts, and turned it on and started cutting some concrete, and the concrete cutter started shaking violently. So he turned it off and looked around, inspected it. He couldn't find anything wrong. There was a blade that said wet on the outside of the blade, and a little note there that said, keep blade wet in order to avoid degradation. Now that sounds like degradation of the blade. And in fact, if you don't keep the blade wet, you'll get killed. But the instruction said, keep blade wet to avoid degradation of the blade. And so he couldn't find anything wrong. The thing was vibrating. He turned it off, inspected it, couldn't find anything wrong. So he turned it back on and cut some concrete for a little bit. And then this thing started shaking violently again. The kill switch was down there near where the blade, where the rotating concrete cutter was. The kill switch was down. He had to use his foot to turn the kill switch on, to turn it off. So when it started vibrating violently, he put his foot there, turned the kill switch off, but by that time the blade had shattered into pieces, and the housing for the blade didn't contain the pieces. The pieces flew out of there, cut his foot up badly, and he's really messed up. His right foot's something else. You wouldn't want to look at it. And they hauled him off to the hospital, and he's got these huge hospital bills, and he's got permanent injuries to his right foot, lots of pain and suffering, couldn't go to work, and so forth. And so now he wants to know, well, what can I do about this? Who can I recover from? And that's one of our examples. The second example is Sally. You recall that Sally there was an allergy medicine, a new allergy medicine, and it was advertised on the media as safe and effective for controlling allergy. She went to her physician, got a prescription, bought the medicine, started taking it. Now the company that was producing this knew that in rare cases this would cause permanent blindness, but they didn't put that in their advertisement. They just said safe. Now the doctor knew, but the doctor didn't tell her. So she started taking this medicine for the allergy, and about 6 months later she is blind, and totally blind in one eye, and the other eye is on its way towards total blindness. And she wants to know, well, what can you do here? I'm blind now. All I did was to take this allergy medicine. What can you do for me? Third case, the airbag case. And this is the case where the child, the 10-year-old child, was sitting in the passenger seat of the car, and riding along in the car, and the driver of the car, her dad, had an accident. The airbags went off at 1,000 miles an hour and hit her in the face. And now the company that made the car and the airbags knew that on rare occasions, if a child is sitting in that seat and the airbags go off, the child gets hurt, seriously injured. I mean, it wasn't like a scratch. He really got hurt badly. And off to the hospital, medical bills, and all that stuff. Now, they knew that on certain occasions, a child will be injured by these airbags. And they had done some research to figure out what could they do about it. And they had two choices. One was to put a switch on the dashboard so you could turn the airbags on and off. And if there was a child sitting in the seat, you turn the airbags off. But, you know, people forget to turn them back on. So that didn't seem like such a great solution. It was cheap, $5 per car. The other possibility was to put a sensor in the seat. So when a person below a certain weight was sitting in the seat, they could sense it and turn the airbags on and off accordingly. Trouble is that that was a new technology. It hadn't been tested yet, and they weren't sure it would work all the time. So no matter which way they went, it cost $900 per car to put that in it. So no matter which way it went, they had problems. And this is the airbag case, and the kid was injured by the airbag and badly. Our final case is the case of Peter. Now, it turns out that Peter is also the person whose foot got cut up here, but it just happened to have the same name. It's not the same Peter. But Peter went to a car dealer, bought a car, and drove the car over to his girlfriend's house, whose name was Gail, parked it in her garage, and during the night, gasoline leaked from underneath the car, caught on fire, burned down the building, destroyed his car. Now, Peter was a famous guitarist, and his guitar was in the trunk of the car. The guitar was worth $25,000. So, of course, his car was destroyed. The guitar was destroyed, the car was destroyed, and the house was burned down. Gail's house, Peter's guitar, and Peter's car. And now what had happened is that when he bought this car at the dealer, the gas line that went from the tank up to where the engine was, that gas line was a little bit too low underneath the car. And under certain odd circumstances, you could get caught on something and leak. And that's exactly what happened to him. He drove it over to his girlfriend's house, and some bump was just the right size and so forth. And the gas line got snagged. And when he parked it in his girlfriend's garage, not knowing it, the gasoline leaked, and that's how the place caught on fire and destroyed the car, his guitar, and the house. And they all want to know what can they do about it. So those are our three fact patterns. Now, to understand what people can do about this, these people say, well, you know, there's several things we can do. One of the things we might do is to hire some big guys with weapons and go over to these people's houses, the people who made the concrete cutter, and say, we want some money now or else. Well, that's one solution, might work. But if they want to use the court systems to get money, then they got to go to the court system, and the court system says, look, we will compensate you if you can establish that the court system says, we will compensate you if you can establish that someone intended to injure you. The common law courts have rules about that. Somebody intends to injure you and they actually injure you, then you can get compensation by going to the court, proving the intent, and getting your money. Also, if someone was negligent towards you, that is, they had a duty to you and they breached it, duty of due care. If they breached their duty to you through negligence and you got injured, then the court system will give you money for that too. Thirdly, if people are engaged in certain kinds of ultra-hazardous activities and you get injured because of that activity, people are dynamiting to make a road or something, and the dynamite goes off and you get hit in the head by a rock or something. Well, that's an ultra-hazardous activity. And if anybody is injured because of the ultra-hazardous nature of that activity, then you can recover for that. It doesn't matter how careful the dynamiters were. If somebody gets injured because of the dynamiting, strict liability, you got to pay for it. Likewise, somebody's got a swimming pool that's a quarter of a mile away and they're blasting and the tiles in their swimming pool crack because of that. Doesn't matter how careful the construction people were, they got to pay for the swimming pool. That's strict liability. Now, we're talking about products liability here rather than blowing up mountains and stuff. And there's a similar thing that happens with strict liability in products. If I am the maker of a product and I put this product out there into the stream of commerce, usually when I make products, I don't make one of them. I make lots of them. I make hundreds. I make thousands. I make tens of thousands of these things and put them out there for sale. Now, if this product which I made is just too dangerous to be out there at all, not reasonably safe, The second restatement talks about being unreasonably dangerous. The third restatement, which we'll use most of the time, talks about being not reasonably safe. But whichever that language that you use, if you put a product out there that's too dangerous to be there, not reasonably safe, and there's going to be thousands of them out there. And you can imagine a huge number of people that may get injured by this product that's not reasonably safe. And so you see the problem that you put the product out there, huge numbers of people get injured. That ought to be treated like strict liability in the same way that dynamiting or blowing up a mountain to make roads and stuff should be, because of the huge number of people who get injured by putting that product out there. And so the deal is that if you put a product out there that is too dangerous to be there, not reasonably safe, and we have a name for that, we call that product defective. So if you put a defective product out there, then it can cause enormous harm. There's strict liability for everybody who's injured as a result of putting this defective product out there. And anybody who puts the defective product into the stream of commerce, that person's strictly liable. And if you look at the commercial chain of distribution of a product, it begins with somebody designing the product, then somebody manufactures the product, then the product gets adequately labeled with instructions and how to use it and warnings about things that may go wrong and advertisement. And so you get information about the product. So again, you design the product, you manufacture the product, you get a bunch of information about the product from a variety of sources, and then the product is put into the commercial distribution system, trucks, airplanes, trains, and so forth. It eventually gets to the retailer. The retailer sells it to the consumer, and now the consumer's got it. It's got this car, this concrete cutter, the allergy pill, and the consumer gets it, and finally the consumer gets hurt. And sometimes it's not the consumer that gets hurt. Sometimes it is a bystander. Here we have it right here. This is the commercial chain of distribution. Product gets designed, manufactured, it gets labeled in some way. By label, I'm not talking about just the label on the container. I'm talking about all the information that the person gets about the product: advertising, labels, instructions, warning books, all that sort of stuff. So a product gets adequately labeled, then it gets into the distribution chain, gets to the retailer, consumer gets it, and the consumer may get injured or some bystander may get injured. Now please notice that in the case of the child riding in the car, the child didn't buy the car. Okay, so that wasn't the purchaser who got injured. In the case of Gail's house, Gail didn't buy the car. Her house got burned down, but Peter bought the car. And so it's not always the person who bought the item that got injured. It could be a bystander, a family member, or someone of that sort. So this is a commercial chain of distribution, and what we have here then is that if you're going to go to the court systems and get paid, the court system says if you can prove that someone intended to injure you and you got injured, you can collect. If someone was negligent and injured you, you can collect. If they put a defective product into the stream of commerce and you got injured because of that, you can collect. And this third group of warranties here, we'll come back and talk about them because it's kind of a different class of things. So we're at the point then where these people who got injured, the person who injured, whose foot's all messed up, the child who's messed up, Gail's house is burned down, poor Sally can't see anymore because of the pills that she took. So those people, they go to court and they try to prove this stuff, and that's how they can recover. So now let's look at each of those. Here are the questions, the bar examples that I asked you to read. The bar examples from February 97. This is the injured foot. July 02 is the blind person going blind because of the allergy medicine she was taking. July 06, the airbags injured someone. And this is my example here where Gail's house burned down and Peter's guitar is burned. And also Peter's car is destroyed, by the way. And so these are the injuries and these people want to recover. Let's begin with intent. And let's begin with the foot, with Peter's foot. So Peter's got all these medical bills and everything, and he wants to get some money. So what he does, he goes to court. He says, I want to prove that somebody intended to injure me, and I got injured. Because if people intend to injure me and I get injured, I can collect from them. So I got to prove somebody intended to injure me. Well, you look at Peter and his foot and everything that happened to him, and who are the people that might have contributed to that he might be able to collect from? And the answer is only those people who are in the commercial chain of distribution of the product. People who had nothing to do with the product, of course, are not going to collect anything. But the people who had something to do with it might be able to collect from them. So we look at all the people in the commercial chain, and here they are. So Peter, with his busted foot, says, did anybody in the design phase, the people who designed this product, were they intending to injure me? No. Manufacturing? No. Labeling? No. There's nobody here who intended to injure Peter. And so if Peter sues based on the intent to injure him, he's not going to get anything. and let's try somebody else. How about Sally and her blindness? Sally says, okay, did anyone intend to blind me? And she says, well, now hold on a second. She says, now, no one consciously says, I'm going to get Sally. They didn't do that. But, you don't have to do that to intend to injure somebody. The most famous case is the case of the Ford Pinto, and Ralph Nader, you recall, made a reputation over that. And what happened with the Ford Pinto is that the Ford Pinto was built, and there was a gasoline tank behind the front seat of the car, and actually further back. But they were able to prove that under certain kinds of accidents with this Ford Pinto, that the car would catch fire and the people would not be able to get out. They'd burn to death before they got out of the car, under certain odd types of accidents with the Ford Pinto. And so the Ford company decided, well, moving that gas tank is going to be expensive, and we'd rather just pay a few people who get injured when our car has that kind of crash. We'd just rather pay them than to move the gas tank. And Ralph Nader was able to prove this, and he got huge punitive damages from the Ford Motor Car Company because of that. And the idea is that if you do something that is substantially certain to cause somebody to be injured, that's the same as intending to injure them. You go to a ballpark that's just packed full of people. There's some sports event going on there, and you throw a huge rock over into where all those people are sitting, and you say, oh, I didn't intend to injure anybody. Well, it's substantially certain that someone's going to get injured by that. And when you do something that is substantially certain to injure somebody, it's the same as intending to injure them. So now we bring that back to Sally and her blindness here, and we know from the facts that you just read that the company that made this pill knew that on rare occasions, not very often, just like the Pinto, on rare occasions that this use of this pill will cause total blindness, permanent. And they knew this, but they didn't put it in the ads. They didn't tell her, and they didn't warn her with anything on the labeling or anything. Now, I told the doctor, who was the learned intermediary, and the learned intermediary should have told her. The doctor, no doubt, was negligent. But they know that people are sometimes negligent. And something that's that dangerous, you can't not rely on someone else to be sure to tell people how dangerous it is. So you're almost certain that if you put thousands of these allergy pills out there on the market, and somebody is going to be one of those people who gets totally blinded. Turned out to be Sally in this case. And so that amounts to intent. So if Sally sues the company for battery, because we're substantially certain to get it to happen, she can get punitive damages for that because it's malicious, it was intentional. And so when Sally goes to court, yep, she can get something under intent. She can sue for intent and recover. How about the child and the airbags? Well, the child and the airbags, that's a little different situation because there again, the company knew that if you put a child in the passenger seat, that rarely, occasionally, a child will be injured by the airbags going off. So they knew that too, just like the Ford Motor Car Company, and just like the allergy pills. But the difference here is that in the case of the child and the airbags were put there to reduce the likelihood that the child, whoever's sitting in that seat, would be killed by the auto accident. So they reduced that dramatically by putting the airbags there, but they left some danger because of the airbags. So it wasn't like they created this danger, like in the case of Ralph Nader and the gasoline tank. The Ford Motor Car Company created that. The allergy pills, they created that. But in the case of the airbags, they were trying to reduce the harm from the accident, and this is just something that's left over. And it turns out that that's as safe as they can make it because they're trying to find out a way to make it safer, but they haven't been able to do that yet. So you don't have intent in the case of the child because although it was substantially certain that someone would be injured, they can't make it any safer. They're trying to figure it out, but they can't do it. And finally come Peter's, Gail's whose house got burned down because of the leaky gasoline, and no one intended to burn her house down. No one intended to destroy the car. It was just designed negligently. And so in all these cases then, the only one where you would do the analysis for intent would be the one for the allergy pills. Now we next turn to negligence, and if someone was negligent, meaning that they had a duty to whoever the foreseeable plaintiff was, they have a duty, they breached the duty causation, it caused the harm, damages, defenses. Regular negligence analysis here. Thing is that you got to, if your here are your clients, and they're claiming somebody was negligent, well, they got to find somebody over here who was negligent in order to sue them. And they got to prove these components. Don't do half of this when you do it on the exam. You got to, if you find somebody over here you think was negligent, you got to do the whole analysis. So let's take a look. Let's take first at the concrete cutter. Concrete cutter, this person says, hey, my foot's been beat up. I got these big hospital bills. I want somebody to pay. I'm going to find somebody who was negligent to me. Who am I going to find? Well, I start over here with a designer. This designer, I mean, just intuitively, you put the kill switch down there where the rotating blade is, and you got to use your foot to turn it off. I mean, that obviously is creating far more danger, far more risk than was necessary to do that. And so you won't have any trouble using the risk utility analysis to show that putting that switch there was negligent conduct. So go through your analysis here, show that that was negligent conduct. Duty was owed. Now be careful here, because the people who are designing this more, they have to have a duty. They have a duty of due care to the foreseeable plaintiffs. And if you're designing this concrete cutter, then you know who your foreseeable plaintiffs are. You know who are the people that might be injured by what you're doing. Who are the people? The people going to use the mower, and the people who are the concrete cutter, and the people who are nearby. And so those are the people you can foresee may be injured. And you've got to take measures to not expose those people to unreasonable risk of harm. Well, obviously you can establish that the people who designed this concrete cutter and put the switch down there, that was under the risk utility analysis, that'll turn out to be negligent. So that's this person you found negligent design. Was it negligent manufacturing? Look at everybody here now in the commercial chain. We have negligent design. Do you have negligent manufacturing? Well, there's nothing about the manufacturing of the concrete cutter that seemed to be wrong. I mean, it came off the assembly line just the way it was supposed to. And when it comes off the, you build a car and you're supposed to have 4 bolts holding the wheel on, and it comes off the assembly line with 1 bolt holding the wheel on. Well, that car was made negligently, and you can use Ray Zipser or something to show that that was a negligent construction of the car. So the concrete cutter, obviously there was negligence there, but so you have negligence in the design. You don't have negligence in the manufacturing because the concrete cutter was made the way it was supposed to. Instructions about the use of it. Well, the blade said wet, and it said wet, but didn't explain to you that if you don't keep this blade wet while you're cutting the concrete, it's likely to shatter and kill you. All it said is that keep the blade wet to keep the blade from degrading. And so those instructions were obviously not adequate. Again, you can show that there was negligence in providing those kinds of instructions. Negligent instructions go through your whole risk utility analysis. The distribution chain, there's no one that's driving the trucks or trains or anything that was negligent here. The retailer wasn't negligent. The consumer wasn't negligent. The consumer put it together the way it was supposed to, and it came apart. Well, the consumer is the complaining party. So the retailer wasn't negligent. So you've gone through 1 through 5 here, all the people in the commercial chain, and the only one in the case of the concrete cutter we found was negligent, probably the designer. In the case of the allergy pills that made this person go blind, was there somebody negligent in that chain? Well, the people who designed the drug, did it to sort of prevent allergies, and it had the side effect of causing blindness. Well, the FDA has already approved that drug. And so since the FDA has already approved the drug, they've already tested and decided that, the benefits outweigh the problems. And they've decided that this drug is okay to be on the market. So the drug is not manufactured negligently. It wasn't designed negligent. It's just that you got to warn people. You got to tell people this may cause blindness. So we're not going to find anything in the design because the FDA has done that already. Manufacturing, no. Again, we're talking about the allergy pills here in Sally who went blind. There's not a design, not a manufacturing defect. There is an information defect because she wasn't told. And in fact, her not being told about that, we've decided that really that was intentional. And so it wasn't even negligent, it was intentional. This chain of distribution, no negligence there, a retailer, nobody was negligent. So when you sue for Sally, Sally's suing saying you people were negligent, we won't get any place because we'll get place with they were at least, they were negligent in not telling her it may cause blindness, but it's worse than that. It's not just they were negligent, they told her the product was safe. So they lied about it. It's not just negligence. So she's not going to get any place with negligence. She'll get her recovery under intent. The child and the airbags, well, again, the designers of the airbags, they couldn't find a safer way to do it yet, so you don't have negligence in the design or manufacturing or information. You know, the child riding in the airbag, you know, any warnings you can give them, it's not going to do any good. The child sitting in the airbag, car's moving, what you going to do? Put a sign on the dashboard that says, in case of accident, be sure to duck so the airbag won't hit you in the face. You know, it's ridiculous. So there's no negligence in the labeling. There's no negligence any place along the way here. So when the child sues for the damage caused by the airbag, there's no negligence. It's not going to be able to recover. Now, and finally, please notice that the child didn't buy the car any more than Gail bought the car, Peters bought the car. So once again, you've got the designers, whoever's designing this car or whatever it is they're designing. They got to look ahead and say, who are the people that might be injured by what I'm doing? And if the people who might be injured by what I'm doing, I have to think about the way they may be injured and try to do things in my design to not expose them to unreasonable risk of harm. And so that's the point I'm making here is that it's not always the purchaser who may get injured. In the case of the child in the passenger seat, it's not the purchaser at all, but the child still is in the passenger seat and may get injured. In the case of Gail's house getting burned down, she wasn't the purchaser, but it's still foreseeable if you're designing this car and you have this gas line that runs from the tank underneath the car up to the motor, and you realize that if you put that gas line too low to the ground, it may get snugged and leak, and obviously if it leaks, it may catch fire. You could burn down anything. So Gail is a foreseeable plaintiff, and you should have been able to recognize that. So in the negligence cases, then, the ones where you should recover for the concrete cutter, the person's foot, Sally who went blind, that was intentional, not negligence. The child and the airbags, you're not going to get anything because the child, the airbags was as safe as they could make it. Gail lost a house, she can recover for the design, whoever designed the car, and Peter's guitar also. So there's lots, that's a design defect. There were no manufacturing defects in any of these, and that's how you would do those. So that takes care of intent, negligence, and then it brings us to strict liability. Now, strict liability is really what this lecture is primarily all about, but I wanted to go through to review these. We've done these, the negligence and the negligence has been done on another video, and the warranties have been done on another video, although we'll run through them here quickly. So we are now at this point, strict liability, and that's really what this lecture is primarily all about. It took us a while to get there because I wanted to use this time to review. So strict liability, what are the elements? What do you have to prove? Well, first of all, you got to decide, does strict liability even apply to this fact situation? Because we're talking about strict liability for putting a defective product into the stream of commerce. And so if I build a whole bunch of houses in a housing development, is that going to be treated like a product? And also you got to be in the business of selling or distributing that product to someone. So let me suppose that I am a friend and I let you use my car. Well, I'm not in the commercial chain of distribution, so I'm not liable. The car manufacturer may be liable. What about the cases where I go, and it's got to be new equipment, used cars, used things, these rules don't apply, strict liability for new stuff. Well, what about the case where I go to lease a car from somebody? They got a car, they lease cars, and I go to lease a car is defective and I get injured. Well, are they treated as being in the commercial chain of distribution of those cars? And the answer is yes. What about the case, it's got to be a new car, but they still are treated that way. What about the case where you buy a car and the car isn't a new car off the factory floor, but the company says, we have refurbished this car and we've done, it's like new. The car is like new. And you're going to treat that like a new product? And the answer is yes. And so you have to look at some of the details to be sure that strict liability applies, that you really are distributing a product and not a service. Next, the product, if you're going to recover strict liability, you have to prove that the product is defective. And as I mentioned, this is where our lecture is going to focus on primarily here today, that the product can be defective under the standards of the second restatement or the third restatement. These differences we're going to be talking about. And then the causation, obviously, the defective part has to cause the harm. You've got to be damaged and watch out for the defenses. Now, we're going to turn then to the analysis of, is the product defective under the second and the third restatement? strict liability. Does strict liability apply? We talked about that briefly. Leased goods, got to be in the commercial chain of distribution. It's got to be a new product. Like new things still count. Was the product defective? This is our big deal here. And we have two theories we can use. The second restatement has been adopted by essentially every state in the country. But the third restatement is the new one, and it is being adopted rapidly, and it will soon have taken over. So we're going to do most of our analysis under the third restatement rather than the second restatement of torts. The second restatement, again, a lot of states still have adopted that, so we have to go through it quickly. Under the second restatement, how do you decide if a product is defective? It's so dangerous that it shouldn't be out there at all. And if you put it out there at all, you're strictly liable for any harm that's caused. How do you decide whether or not the product is that dangerous, defective? And the answer is that this is the rule. If it's in a defective condition, unreasonably dangerous. This is the restatement 402A, and I urge you to read 402A. And in fact, I would like it a lot if you stop this video right now and got a copy. It's on the network here. You can get it down. Get a copy of the second restatement 402A and the third restatement, section 1 of the third restatement, that gives you these two rules. Because what I have here on the board is a summary of that rule. You need to see the actual rule because the bar examiners want you to know what the rule says. Third restatement, we also have a rule, and we'll talk about that. But I want you, again, these are like tight summaries that I can write on the board. Read the rule. Read the rule so that you really understand it. So I'm going to stop for a second here and ask you to just stop the video, put it on pause, get a copy of the second and third restatement and read it, because this is extensively what the rest of this lecture is about. And this is the primary analysis that the bar examiners are looking for in a strict liability problem for products. So I'm going to pause for a minute while you get the second and the third restatement and read it. So we're on pause for now. Okay, assuming that you have located the second and third restatement and read it, the second restatement in summary says that the product is defective if it's in a defective condition, unreasonably dangerous. A defective condition, unreasonably dangerous. Now this whole phrase, I put it in quotes here because it's taken as a collective phrase. You don't break up each of the parts separately. It's taken collectively. And when you look at it collectively and you ask yourself the question, how do you decide if a product is in a defective condition, unreasonably dangerous? Defective condition, you buy a bicycle. I said you don't take it apart, but I want to make sense of this for you. You buy a bicycle, and the bicycle's got a scratch on the fender. Big new scratch, brand new bicycle. Scratch. This bicycle's obviously defective. But even though it's defective, does that make it unreasonably dangerous? And the answer is no. It's defective, but it's not unreasonable. How about you buy a bicycle and the handlebars come off occasionally, unexpectedly, and suddenly you've got no handlebars. That bicycle is defective, and that one's unreasonably dangerous. And so the rule here is that under the second restatement, in order for the product to be defective, it needs to be in a defective condition, unreasonably dangerous. And the way you decide that is you use the consumer expectation test. And the consumer expectation test says basically, look, if I'm the consumer and I'm going to buy this product, I have an expectation of a certain level of safety in this product. And if this product is more dangerous than a reasonable consumer would expect, more dangerous than a reasonable consumer would expect, that product is too dangerous. And that's the consumer expectation test. I've abbreviated it here. And that's what the second restatement uses. Now, in your analysis on the bar exam, give brief comment to this. Always do it, but just give brief comment to the second restatement, because the third restatement is replacing it. And even in those places where the third restatement has not replaced the second restatement, its second restatement is being interpreted in such a way as you get the same results on the third restatement. So focus your analysis and attention on the third restatement, even though you give quick lip service to the second. So second restatement, let's take a look at this. Let's start with the concrete cutter. Is the concrete cutter, does it fail the consumer expectation test? Yeah, if you're a consumer and you buy a concrete cutter in a box and you take it home and turn it on, you don't expect that kind of a dangerous thing where you get, instructions about how to use it that are so vague that you end up almost killing yourself. You got a switch down there that you can't get to safely. You wouldn't expect that when you bought a concrete cutter in a box at a store. So that would fail the consumer expectation test. Sally, who is practically blind from taking the allergy pills, consumer expectation test, obviously that would fail. The car, Peter who bought the car and the gas link, consumer expectation would fail that test. And the child who was riding in the car, a child doesn't expect to be injured because they're riding in the passenger seat of the car, seat belts on and all that sort of stuff. Thing is that with the car, the consumer expectation test really, it may pass that because they've made the airbags as safe as they can make them. Okay, they're trying to find ways to make it safer. That's the best you can do right now. So I'm not sure that violates the consumer expectation test, but the other three do. So apply that test, and now we go to the third restatement. This is where most of the analysis is. In the case of the third restatement, the rule breaks up the product and says into its design stage, the designer's, manufacturer, and inadequate instructions and warnings, these three. So a product, what they're saying is that if a product is defective, it can be defective because of its design. It can be defective because it was manufactured badly. It can be defective because there were inadequate warnings and instructions, like the wet sign on the blade. So let's go to the first one, the design. A product can be defective under the third restatement and can be defective because of design. Now, how do you decide if a product is defective because of design? Now, when you manufacture something, it's easy to see if it's defective. You're supposed to have 4 bolts holding the steering wheel on, and it comes out of the manufacturing line with 1 bolt holding the steering wheel on. That was manufactured defective. This product is defective because of the manufacturing process. So if it doesn't come off the assembly line the way it was designed to, the way the other products come off the assembly line, that's a defect in manufacturing. So that one is easy, and that's right here. But we're talking about a defective in design where the product came off the assembly line just the way it was supposed to. It's just that the way it was supposed to is too dangerous. And so how do you decide if the product that came off the assembly line is defective because of the design? And here are the components of that rule. There are 4 parts to it, 1, 2, 3, 4. Part 1, is there a reasonable alternative design? R-A-D, reasonable alternative design. If there is how do you decide if there's a reasonable alternative design? Well, you look at things like factors. You look at like how much would an alternative, safer design cost? What's the state of the art? Does one even exist? Like in the case of the airbags, you don't even have one. You look at what other people are doing to try to make their products safer. And then don't forget that the consumer has a right to choice. That is to say, there's a case where a police officer bought a bulletproof vest. He had a bulletproof vest. Now, when you go to buy these bulletproof vests, there are two styles you can buy in this case. There was one style that wraps around the entire chest of the body, and there's another type that just covers the front and back, and it's got an open side. Now, in the ones that have the front, back, and open side, it's more maneuverable, it's lighter. Some people prefer it just because of that. The one that completely surrounds you is a little bit safer. It costs more, but it's not as maneuverable. And so this officer bought one with the open sides, got into a gun battle someplace and got shot through the side and sued. He's saying your bulletproof vest was defective. And the court says, well, no, you knew at the time that you bought this vest that the sides were open, and you chose that. It's a little cheaper, it's not as safe, you can move around, and you chose that. And we prefer giving people choice. And if either choice that you make, if the choices are not unreasonably dangerous, that's out. That product shouldn't be out there at all. But if the product is, unless it fails the test of being not reasonably safe, then if the product, let me back up for a second. If the product is too dangerous to be out there at all, then of course that's a defective product. But this is giving people various degrees of protection with these bulletproof vests. I mean, the consumer should have those choices. And as long as there's no choice, it's just, if you put a piece of paper in front of you and a piece of paper in the back, call it a bulletproof vest, that obviously isn't going to work. So you got to leave people choices. The mere fact that some choices are better than others doesn't make all the not so good choices defective. So you need a reasonable alternative design, and when you're doing the bar exam questions, this is a big deal, whether or not here. So you need to put some time into discussing reasonable alternative designs. If there is a reasonable alternative design which reduces the foreseeable risk, did the person use this reasonable alternative design? If you had one and didn't use it, why didn't you use it? Then the rule is that if you had one, didn't use it, and if the product is now left in a condition that is not reasonably safe. Now I want you to pay attention to the difference here. Not reasonably safe, that the third restatement uses this language, not reasonably safe. The second restatement uses the language unreasonably dangerous. And be sure that you stick to those two different kinds of languages when you're doing this. If it's not reasonably safe, how do you decide if a product is not reasonably safe? This is how you decide if there is a reasonable alternative design which reduces the foreseeable risk. Was the product not reasonably safe? Use the risk-utility analysis to do that. Okay. So the third restatement says that you look to see if there's a reasonable alternative design which reduces the risk. If there's one exists, you didn't use it. Did that leave the product in a condition that is not reasonably safe? If so, then that product is defective. That's a manufacturing defect. That's a design defect. Manufacturing defect. In fact, let's go through these here for a second. Let's take the case of the concrete cutter. Was the concrete cutter, is it defective because of design? Well, let's take a look. Concrete cutter, was there a reasonable alternative design to the concrete cutter? Obviously there was. And I won't even go through the details. It's cheap. You can move that kill switch around lots of places. There was a reasonable alternative design which would reduce the foreseeable risk, and they didn't take it. And did it leave the product in a condition that's not reasonably safe? Go to your risk-utility analysis, and you'll obviously conclude that the risk created by putting that switch down there where it was and is not justified by the cost or the burden of preventing it or any of that sort of stuff. So the product is left in a condition that is not reasonably safe, and therefore we have a design defect. The allergy pills. The allergy pills, we don't do this because the Food and Drug Administration has already decided that the pill can be used, but you got to give warnings. The child who was sitting in the passenger compartment riding in the chair, the child was there a reasonable alternative design? Well, the answer is apparently no, because they were trying to find a way to make it safer. They couldn't find a way to make it safer, so I'm not sure that that there is a reasonable alternative design. Go through some elements, discuss it here, and say you probably don't have a reasonable alternative design, so that the car with the airbags in it that injured the child is not a defective design. What about the car with the gasoline line running underneath the car that got snagged? Well, there is a reasonable alternative design. Obviously, just put the gas line somewhere else. That would have reduced the risk, and they didn't use it, and they left the product in a condition that is not reasonably safe. How do I know that? Do the risk-utility analysis, and you see that putting that car with the gasoline line where it wasn't reasonably safe. What do we have? The concrete cutter, the blind person, the car, the child, and the car that got burned down. So that you apply design these. That's how you would do it with those. So now, let's go next to manufacturing defect. The manufacturing defect occurs when the product is not, when the product doesn't come off the assembly line the way it was supposed to. And that is a manufacturing defect. Now, when there is a manufacturing defect, that product is automatically defective. It is not a question of whether or not this particular thing made it unreasonably dangerous. In the case of design defect, if you put the kill switch where it was, down low down there, you created a product that is not reasonably safe. In the case of the where we did the we're talking about manufacturing defects, and I'm saying in the case of the car with the airbag, there was no manufacturing defect. There's no manufacturing defect for the concrete cutter. There's no manufacturing defect for the allergy pills. There's no manufacturing defect for the car with a gas line underneath it. So there's simply, we don't have any examples where there really was a manufacturing error. But my point here is that when there is a manufacturing error, you don't have to ask the question, did this error make the product unreasonably dangerous? Or pardon me, not reasonably safe. You have to do that for the design defect, and you're going to have to do it down here for the inadequate warnings and instructions. But you don't have to do it for the manufacturing. If the car came off the assembly line in a way that it wasn't supposed to, it is defective, period. Then you look to see, was this defect, you use causation to see, did this defect cause the injury? If so, then you've got a manufacturing defect that caused injury. The last of these is inadequate instructions and warnings. Inadequate instructions and warnings, when do you require instructions and warnings? And the answer is that, that's a problem. That's a serious problem, because when you don't have to warn people about everything. I mean, do you have to warn people that, if you just things that I'm having trouble making up an example, but things that are just obviously dangerous. You don't have to go around telling people that all the time. Do you have to tell people that if you don't put air in your tires, the car you won't be able to control the car adequately, and you may have an accident. You have to tell people that if you don't repair your brakes, you may have an accident. Certain things are just so obvious that you don't have to tell people. On the other hand, there are things where you do need to warn people. And you can see that the boundary between when you do and don't have to warn people, that's a fuzzy boundary. And that's a problem. How do you decide whether or not in a particular situation you really needed to warn somebody? And it's hard to pin that down. But a couple of things you need to know about it. First, you generally use the risk-utility analysis. You ask, would warning someone have made the product safer? Because sometimes you warn people and it's not going to make any difference. Other times you warn people and it may make a difference. So you use risk-utility to see and you also, if you're going to warn people, there's a cost of warning. You got to put signs up. You may have to do a bunch of other things to warn people. So you look at the risk that's created by not having the warnings and the utility, how difficult is it to warn people? Will the warnings do any good or not anyway? So this is really more of a common sense, but that's what you do. To give you a couple of examples, there was a case where a person had a table saw. And this is actually in a meat cutting place. It wasn't a table saw, it was a rotating blade that cut meat. And if you put a sign there in front of the rotating blade that says, "Danger!" Well, you can say, isn't that so obvious that you don't need to tell people that that's dangerous? And it's on the edge. The real question is, would it do any good? If you put a sign there that says "Danger" in big red letters, most people will see the rotating blade and not do it, but will that save one person? Will that prevent some one person and get them to be a little more careful because they'll just be a little more careful because this big sign that says "Danger"? And so if it would reduce the risk, the language is reducing the foreseeable risk. So if it will reduce the foreseeable risk and it's not too difficult to put a sign there, you probably ought to do it. In that case, the court said, yeah, you needed to put a sign there. Somebody hurt themselves. Next thing is that sometimes under when is the writing required is federal preemption issues. Because sometimes there's a federal law that says, here's the kind of warning we want you to put on here, cigarettes. There's a warning on the package of cigarettes. And the feds have said, this is the warning we want. Well, if you now sue somebody under state law saying, I don't think those warnings were adequate and I want to sue, well, the feds have preempted the field saying these are the warnings that we want and the state laws don't really matter. So sometimes the kind of instructions and warnings that are required are covered under federal preemption, in which case you can't sue under state law. Finally, if there are a small number of people who may be injured, very few people may be injured by this. In the case of the Pinto car, in the case of the Sally getting blind, taking the allergy pills, there are very few people who may be injured. Do you still have to warn 1 out of 1,000,000 people is going to be injured? Do you still have to warn everybody? What do you have to do? And the answer is that it depends on kind of a trade-off, how serious the injury is. If it's great bodily harm or death, somebody's going to die if they do this, and there's only 1 out of 1,000,000 people, yeah, you better tell them. But if 1 out of 1,000,000 people are going to get a scratch or something, if this happens, well, no big deal. You don't tell them. So there's kind of a trade-off between how serious is the injury and how many people would be affected by it. The rule for deciding if a warning is inadequate instructions, warnings, the rule is, would the warnings reduce the foreseeable risk? If you're going to give somebody a warning, it's not going to reduce the foreseeable risk, don't bother. And you did not provide the warning. If it would have reduced the foreseeable risk, you didn't provide the warning, and the product is in a condition that is not reasonably safe. Remember, this is the language of the third restatement. The product is not reasonably safe. Well, you go to the risk utility analysis to decide if the product is not reasonably safe. Examples. In the case of wet on that blade that we were talking about, those warnings were not adequate because the person didn't understand that if you let this blade get dry while you're cutting cement, you may get killed. And so those warnings were not adequate. How would we prove that using the rules? Would it have reduced the risk if we had explained more? Yes, probably. And they didn't, the company didn't put more, better instructions or warnings would have reduced the risk. They didn't do it. Did they leave the product not reasonably safe? Well, yeah. I think leaving this product with those warnings on that blade is not reasonably safe, and you use the risk utility analysis to prove that. In the case of the allergy pill, a warning, the facts told you that if Sally had known that this pill would make her blind or might make you blind, she wouldn't have taken it. So warning the warning would have reduced the foreseeable risk. They didn't take it. The product was not in a reasonably safe condition. Use the risk utility analysis to prove that. In the case of the line running underneath the car, coming up and getting snagged, and that obviously is warnings and instructions aren't going to do any good there, so that didn't matter in that case. In the case of the child airbag, warnings wouldn't do any good, and so that's about it. So that's how you would do the analysis under the second restatement and under the third restatement for the 3 problems that we've just talked about. And now, if we finally move to warranties, now there's a separate lecture on warranties, which I presume you've watched by now, so this is going to be very brief. But the warranties, there are the express warranties at UCC 2-313 and the implied warranties at 214 and 215. The express warranties, you recall, can be any promises that are made regarding the product. Well, in our case, let's back up for a second. The reason you can recover under warranty theories is if I'm the seller of the product and I promise you this product is going to perform in a certain way, and it doesn't perform that way and you get hurt, then you can sue for breach of that promise. Okay? And so that's what the warranties are about, is more fully explained on that video. 2-313, any express warranties that were made. Well, the company that made the allergy pill told Sally on their ads, the product is safe. And it wasn't. So that's a breach of warranty. She can recover for that, get her damages. Problem with the breach of warranty are the privity problems, and that is solved because when these people put out the advertisement saying it's safe, or if they put it on the bottle saying it's safe, however they said it, it was intended to reach the purchaser. And if it was intended to reach the purchaser, I am making that promise to the purchaser, even though I'm the company out, in some other part of the world, and they tell the world that this product is safe. That's intended to reach me, the purchaser. And so they're making the promise to me, and if the product is not safe, I can sue them for breach of that promise. That's 2-313, more fully covered on the video on that. Now the implied warranties, fit for ordinary use, adequately packaged, adequate instructions, adequate warnings. You see that coming up. These are the ones that are tested, again, most frequently. There are other things there, but again, read the whole thing, but these are the ones that are tested most often. In the case of the concrete cutter, not fit for ordinary use, inadequate instructions, inadequate warnings. In the case of the allergy pills, you claim that it was not fit for ordinary use because of inadequate warnings. In the case of the airbags are probably did not breach any implied warranties because that's as safe as they could make it, and warnings wouldn't do any good. Gail's house, when she sues, she'll say the car that burned my house down wasn't fit for ordinary use. Peter sues for his guitar. He'll say the car that destroyed my guitar wasn't fit for ordinary use. Peter would not talk about these other things regarding his guitar in the trunk of the car. And so that is how we would deal with the express and implied warranties. And when you do a product liability problem, then we can go back to the beginning. To summarize, the way we do a products liability problem is the person will sue for intent. They're looking for anyone in the commercial chain of distribution that they can claim intended to injure them, in which case, if they can do that, they've got battery, they can get punitive damages. Negligence of anybody along here, strict liability for everybody, because the reason it's strict liability for everyone in this commercial chain is because everybody in that commercial chain participated in putting the defective product into the stream of commerce. And the deal is that if you put that defective product out there, you're putting large numbers of people in danger. So everybody who participated in putting it there, the retailer, the truck driver who drove it to the retail store, the people who manufactured, the people who designed it, everybody. If you participated in putting it into the stream of commerce, you're strictly liable with everybody else. And of course, certain people in that stream can get indemnity from people further up the stream, but they're still liable. So in the products liability analysis, then again, you look for intent, look for negligence, strict liability for putting the defective product, and you prove that it's defective by these methods, second or third restatement. And don't forget that in negligence, you have to do the whole thing, do the entire analysis, duty, breach, causation, damages, defenses. When you come to strict liability, you have to do the whole thing, and causation. And then in strict liability, you establish that the product was defective. After you establish the defective, you go to causation, damages, and defenses. Now, we didn't talk very much about defenses, but let me say 2 words about it right here that may be useful. And that is, under defenses, the big item here is comparative negligence. So that you will use comparative negligence as a defense to strict liability, and you get that comparative negligence in a lot of situations where people use it in place of the duty to mitigate. Someone gets injured, they don't go to the hospital and take care of themselves. The situation gets worse because of that. That normally would be treated under duty to mitigate. A lot of jurisdictions treating that under comparative negligence. You can do that. Comparative negligence when people have bought a car and the car injures them, but at the time it injured them, they were doing something foolish in the car. They were driving way above the safety limits of the car, so they were engaged in some risky activity along with the car being defective. You use comparative negligence in those kinds of cases. And that is really the way you do these products liability problems. You do intent, negligence, strict liability, and the breaches of warranty. The privity is going to be the problem here with the breach of warranty. When you do each of these, be sure to follow it through with all of the steps. When you do negligence, do the whole thing. Don't just say negligence and stop there. If you're going to have to do negligence, do the entire cause of action for negligence. Strict liability, here's the entire cause of action for strict liability. Do the whole thing. Don't just do parts of it. Breach of warranty, same thing. You do that and you are almost guaranteed to get a very high grade on any products liability problem that appears on the exam. And there's one more thing that I noticed that might help you get an even higher grade on the bar exam, and that is to watch your spelling. Someone spelled this incorrectly. I noticed this when I was lecturing. The word label is spelled wrong there. And since label is pretty important, in terms of things being labeled, I would spell it correctly. That is the end of this lecture on products liability.